Hello everyone, welcome back. This is Louisa Turnip, your corporate lawyer from Jakarta. Today I would like to talk about nominee agreement. Currently, I'm handling two cases revolving dispute on nominee agreement. One of my clients is in a position of beneficiary, they are foreigners, and the other client in a position of nominee. So this has given me a broader understanding that I'm going to share with you, hoping that after watching this video you will have a better understanding how to conduct your investment and to make a better decision in either or not you're going to enter into a nominee agreement. So, nominee agreement, this is very popular among investors, and for fact there are many people think that this type of agreement is legal. And I totally understand why that is the case. And that's because this type of agreement indeed in the gray area. You cannot say black and white, because one of my clients actually already won the case all the way up to Supreme Court. Not only in the district court, meaning he got the favor as if the all argument in it is legitimate. However, though, the difficulties is during the execution of that decree. So, you win the case in court, however, you cannot execute it. It's quite pointless. So now I would like to talk about why nominee agreement is illegitimate and where is the failure, why it failed to protect your right, your investment. So first of all, nominee, let's define it. Let's define what nominee. Nominee does not recognize by the Indonesian's law, the Indonesian's legal system, which we follow the civil system. Nominee comes from English common law, which it defines according to Black Law's dictionary. One is designated to act for another, become a guarantor or guarantee for another, to represent another for another. In this context, the Indonesian will be the nominee and foreigner become the beneficiary. And this type of agreement is almost as if it's legitimate if you look at it from the ICIC, which is the KUH Perdata number 1320. In this article, it stipulates about the procedures and requirement of what make an agreement legitimate and binding. There encompasses 4 things, and number 4 is the one that challenged its legitimacy. It challenged its strength and often failed to protect. Not only often, it's definitely failed. Or let's say, because in this situation, you can still find legal resolution, even though you might, but in a very peaceful way, you approach the other party and try to go with the win-win solution. So, in other words, you already spend lots of money in the court, but in the end, you have to go through negotiation again to your nominee, right? So, the problem with this nominee agreement is that many people perceive as this is legitimate because the ICC is indeed grant every individual or body entity or PT, let's say PMR, everybody can make agreement, and the agreement will be binding as long as it complies with the procedures and the requirement, which is the parties concluded in the agreement, they consent, and that agreement that concluded the parties, they are competent, that referring to that each parties are by law are competent to deliver the duties and also the right, and that the agreement must to regulate a valuable object, means land, obviously, is a valuable object. Number 4, here is the weakness. Why it failed to protect. Why this failed. It says that that agreement must not in conflict with the prevailing law. So in this case, if your intention want to get land, which is the Esheim one, Esheim means it's a title of ownership, owning land in Indonesia that can allow you to have it for eternity, mean for you, to your children, to your grandchildren. The rest, very limited. If your intention want to get that and you use nominee agreement, you will fail, because this nominee agreement is breaking the agrarian law in the first place. That, ladies and gentlemen, why nominee agreement is illegal. Even though you might win in the district court, which is often declined by the court, but if you can make it all the way to Supreme Court, you are fantastic. But again, I would rather, as a lawyer, this is our job. We like to handle cases because that's how we make revenue. But if you look at it from humanity perspective, of course, you will rather want to fail that, or your lawsuit to be declined right away, so you don't have to waste your time and your energy all the way to Supreme Court, because if eventually this decree inexecutable, cannot execute it. So this is why I've always been vocal about be cautious with your intention wanting to involved or wanting to go with the opt for nominee agreement. It is illegal. I think that's all. If you have any question and if you have any concern about your asset in Indonesia, let me know in the comment section. Please, disclaimer, everything that I say here is not for you to apply for your legal case, to your legal dispute. Please consult with your lawyer to get a customized one, because every cases are different and it shall be handled in a very customized way. Thank you for watching, and I'll see you my next